Libel and slander have a lot of similarities, but libel is defamation by written words or communication in some other tangible form, while slander is defamation by spoken words or gestures. The law treats libel more harshly than slander because it's permanent and it reaches a lot more people. Because of that, broadcast defamation is typically treated as libel because it reaches a large audience. If something's in a speech and it's seen by 30 people, that would be slander, but if it's something broadcast on the airwaves, it would be treated as libel. And it's best to be aware what will get you into trouble because libel suits are expensive even if you win. There are 6 elements of a libel suit, and to win a libel suit, if you're suing for libel, you have to prove all 6 of them. 5 of 6 isn't going to cut it. The 6 are defamation, identification, publication, falsity, injury, and fault. The first element we'll look at is defamation. You basically need to prove, if you're suing for libel, that your reputation was injured. A couple steps in this one. First off, a judge determines whether the statement that's being sued over is capable of being defamatory. If not, you're done. You've already lost. But if the judge determines it is something capable of being defamatory, it would go ahead with the trial, and the jury would decide whether a substantial segment of the respectable public would understand the statement as defaming the plaintiff. You see that kind of language a lot in these sort of cases where it's not just would one person think that this is defamation. It would be in general, would people consider this to be defaming? To be considered defamatory, a statement needs to be something that an ordinary reader would find factual and believable. This example is from many years ago. George Harrison, the former Beatle, and the Honolulu Advertiser were sued because of a story. Basically, it was a court order that allowed his neighbors to cross parts of his property to reach a beach. That was the only way to reach it. In the story, Harrison said, "Have you ever been raped? I'm being raped by all these people. My privacy is being violated. The whole issue is my privacy." It was Harrison and the advertiser were sued over this. However, it lost because the jury understood that it was made metaphorically. It was not something an ordinary reader would hear and interpret as a literal accusation of rape. The next step we're going to talk about is identification. You need to prove that an audience would associate you with a defamatory statement if you're suing for libel. Usually this step is a pretty easy one. If you're identified by name in a story, that's identification. A lot of times suits will come about because there are similar names that cause confusion. That's why we're so strict about names in our stories. It also doesn't always require naming the plaintiff. The example here is there was a press release about misconduct by former executives. Didn't name the person, but included a link to the lawsuit naming him. He was fired that same day, so it was pretty clear who it was, and even though it didn't name the person, it counted as identification. Publication is the next element of libel, and again, this is another easy one. Hey, here's the newspaper, or here's the website, or here's the broadcast piece, etc. However, it doesn't necessarily need to be published widely in order to be considered published. Example here is that a man dictated a letter to his secretary accusing the addressee of larceny, and the court ruled that that dictation counted as publication because there was another party involved. If he had typed it himself, no problem, but since he involved the secretary, that counted as publication. We're getting into the little bit trickier elements here. Falsity is next. It used to be assumed that if you were suing over a defamatory statement, that it was assumed to be false. However, that is flipped around now. If you're suing for libel, you have to prove that the statement that was made was false. It's important to keep in mind that something that's can be false but not defamatory, and also statements can be defamatory but not false. So you have to prove both if you're suing for libel. Next step is injury. You have to prove actual injury to be awarded damages in a libel suit. Be damage to reputation, humiliation, mental anguish, those sorts of things. This is another one where it used to be assumed that a defamatory statement caused injury. Again, this is flipped around as well, but the bar for proving injury is not very high. If a statement that's being sued over makes people think you're involved in a scandal or something like that, that would be enough to count as injury. The example here, another identification issue. There's a story in the Arkansas Democrat Gazette a number of years ago. The Whitewater scandal figure was Eugene Fitzhugh. They accidentally published a picture of J. Michael Fitzhugh with the story. J. Michael Fitzhugh sued, saying he was associated with a scandal now because of what they'd done, and he won his suit. Now we're getting into the fun stuff. Fault is often the most crucial issue in a libel case. It has to do with the state of mind of the person making the defamatory statement. And there's a couple different levels of what you have to prove if you're trying to prove fault. If you're a public official or public figure, you have to prove what's called actual malice, which basically means that the publisher knew the statement was false or had reckless disregard for whether it was false, meaning that they should have known it was false before publishing. If you're a private individual, you have to prove just negligence, basically that the outlet publishing this acted unreasonably under the circumstances. Actual malice is why there aren't a whole lot of libel suits, and the ones that there are rarely win. If you're a public figure or a public official, you have to prove actual malice, which is very difficult. You have to prove things along the lines of that the defendant had to know the statement was false or had a high degree of awareness of its probable falsity. If the defendant knew facts that would call the story into question and still ran with it, or refused to examine evidence that would show that it was false, again, still ran with it, that would be a problem. If the defendant relied on an inherently unbelievable source, someone who's known for not being truthful, or someone who might have a grudge against the person, something like that, so there's a reason to doubt whether what the source is saying is true, or publishing an improbable story without investigation or simply making things up. That's why we don't report on rumors or things like that, or again, hopefully it's obvious by now that we don't want to just make things up. Despite how difficult it is to prove actual malice, there are some examples of successful cases proving it. This one is a story in the Boston Herald that reported a judge was too lenient on criminals. That was the whole idea behind the story. And there's a quote from the judge, allegedly from the judge, where he was saying about a teenage rape victim, "She can't go through life as a victim, tell her to get over it." It turns out the sources for the story were prosecutors who knew that the reporter held grudges against the judge. And there's no evidence supporting the quote was ever said or said in that way, so that was a rare successful case where a plaintiff was able to prove actual malice. More common are unsuccessful cases trying to prove actual malice. In this one, it was a Fox News program that used quotes from a parody news website, but they were treated as if they were real. They basically believed that they were real comments berating a school superintendent over what he supposedly said. The judge concluded the Fox personalities were negligent, gullible, and unprofessional, but generally believed the story was true, so therefore it wasn't actual malice. Basically, they should have known it was true. They didn't. They weren't very good at their job, but because they generally believed it, it's not actual malice. Whether someone's a public figure, public official, or private individual is a pretty important step in a libel case because it determines what a plaintiff needs to prove to win a case, whether it's actual malice or negligence. The Supreme Court has given only limited guidance about which people fall into these categories, however. Public officials are people who have some sort of position of authority in the government. Just because you're on the payroll in government does not make you a public official. If you're the Merle College janitor, you're not a public official, even though you're a public employee. People who are like legislators, city council members, school superintendents, governors, those sorts of people who have positions of power, those are pretty clearly public officials. Law enforcement officers and people in those areas are also generally considered public officials because of the power they have over the public. They might not be household names, but they do have power over the public. Public figures, there's a couple different types. A general purpose public figure has great persuasive power and influence. Basically people who everyone knows, celebrities, sports figures, those sorts of people. Those are general purpose public figures. A limited purpose public figure holds that same sort of status, but just in connection with a certain topic or issue. If you organize an abortion rights march, for example, in relation to that event, you would be considered a public figure. Now that we've talked about what you need to prove if you want to win a libel case, let's talk about what you want to do if you're facing a libel suit and want to defend yourself. The first defense, in fact, we always say that the first and best defense to a libel suit is truth. If a plaintiff has to prove falsity to win a libel case, if you can prove that it's true, you've won. Again, it doesn't need to be necessarily 100% accurate in every detail. As long as the gist of the story is accurate, you're going to be fine. Fair report privilege is the next one. Basically, as a reporter, you're protected from libel suits if you're accurately covering what happens in the course of government, courtrooms, legislative chambers, official documents, public officials' comments in the course of their official duties, those sorts of things. So if the police chief tells you something that's relating to police business and you report it accurately and it turns out it's completely made up, the police chief's going to be the one in trouble, not you for reporting it. Lastly, fair comment and criticism basically protects opinion. If it's a statement of fact phrased as opinion, that's not protected. I believe that the mayor does X, Y, Z. That's something that's provable or disprovable. That would not be opinion. But if it's truly a statement of opinion, you're covered. Now we get into privacy law. There are 4 types of invasion of privacy that the law recognizes. There's intruding on a person's seclusion or solitude, giving publicity to private facts, placing a person in a false light, or appropriating a person's name or likeness for one's own benefit. An intrusion lawsuit requires that a person intentionally intrude on the solitude or seclusion of another person in a manner that would be highly offensive to a reasonable person. Again, that's some of that language you're going to see a lot in these sorts of things. It's not just that it's offensive to one person, it would be something that would generally be considered offensive. As a plaintiff, you have to show that the defendant intruded into an area where the plaintiff had a reasonable expectation of privacy, and the rights of privacy generally do not extend to things that happen in public places. So if you're walking down the street and someone takes video of you, you don't really have an expectation of privacy, so there's no intrusion there. If you're in your front yard doing something and someone takes a photo or a video of it, again, there's no expectation of privacy there because someone just walking down the street can look in your yard and see what's happening. If someone's peeking through your window and looking at what you're doing in your house, that would be an area where you do have a reasonable expectation of privacy, so you could potentially have an intrusion lawsuit. For a giving publicity to private facts lawsuit, you have to prove that the defendant gave publicity to a truly private matter. If it's something that's in a public record, that's not private. A lot of times you'll see stories about the 10 most expensive homes in an area, that sort of thing. That's all public record, so revealing that sort of information is not private. Also, facts that are known to a large number of people are not private. It doesn't have to be in a public record, but if you're sharing some information and it's something that a lot of people already know, you're not going to get sued over that, or at least not lose a suit over it. Also needs to be something that's highly offensive to a reasonable person. Again, there's that language again. And it also has to be no legitimate public interest in the information. If you're a politician or running for office, you have a practically impossible chance of winning one of these suits because courts have ruled pretty consistently that basically anything about someone running for office the public has an interest in. False light suits are similar to libel suits in a lot of ways. Keep in mind, libel is about injury to reputation. False light is basically that someone wants to be left alone. False light requires that publicity place a person in a false light, which seems obvious, and that it be highly offensive to a reasonable person. And an example here, Baywatch actor Jose Solano Jr., who I'm sure we all know and love his work, he sued Playgirl magazine for false light over the cover on the next slide. Basically what happened here is the photo was used without his permission. It was from another photo shoot or a stock photo or something like that. He did not pose for the magazine. He was not in the magazine. But the juxtaposition of that photo and the headlines that are on there basically gave the impression that he had posed nude for the magazine, which he had not, and he was able to win his case because of that. Lastly, we have appropriation. This is when you use the name or likeness of someone for your own benefit. That could be a problem, as you might imagine. The most common type of this is using someone's name or likeness in an advertisement without permission. And it's one of those things that's so blatantly something you don't do that it very rarely happens. You're not going to put Michael Jordan in your ad for something without paying him a ton of money. But hey, we have an example on the next slide. That picture is a billboard that American Apparel put up in 2008 with Woody Allen from one of his movies in it. He was not paid for this. He was not asked whether he was going to be on these billboards, anything like that. They basically just used the picture. So he sued. Basically as soon as these things went up, he sued because he's very protective of his image, and it's clearly the sort of thing that you probably shouldn't be doing. The company initially used a First Amendment defense, but then they actually talked to some lawyers who knew about communication law and very quickly settled for $5 million.